Welcome to Fahey Schultz Berzik Roads monthly township e-letter webinar. This is a follow-up to our December e-letter. Will COVID continue to impact my township in 2022? Looking back on it, COVID-19 has had so many different impacts on municipal organizations, such as townships, since the pandemic started. Anything from ranging how to manage employees with, how long employees must isolate or quarantine when being impacted by COVID-19 to how, we run open meetings. Some of the pillars of municipal operations, and it's brought about other changes such as, the use of American Rescue Plan Act funds, so ARPA funds, and this new category of funding municipalities received from the federal government to respond to the unique situations created by the pandemic. So our presentation today addresses some of the select questions about how COVID-19 will impact your township in 2022. As we speak now in Michigan, there are currently high rates of transmissibility of COVID-19 with the Omicron variant. While this presentation doesn't address all the ways that COVID-19 will continue to impact your township in 22, it addresses some of those big issues that are going to be facing, all different municipalities on this issue. So, Steve, if we want to jump in and get started, that'll be great.
Yep. So the first area that we're going to talk about today is how meetings will be impacted by COVID. And all of you dealt with this last year, all right? We had many developments with the Open Meetings Act, and especially at the beginning, it was trying to determine, first of all, how the heck do you hold an electronic meeting? What do we need for that? What is Zoom? And now you're all experts at this point in a lot of those areas. But I think it's important to have a little bit of a reminder of where we've been and some of the current restrictions and regulations, but also going forward, what some options you might have as you continue to try to hold meetings while this is an ongoing issue. So as you'll remember, last year there were a couple of legislative developments related to the Open Meetings Act. For a while, you were just operating under the authority of executive orders from the governor that gave authority to have electronic meetings. But there were two pieces of legislation that actually amended the Open Meetings Act. These created three different timeframes, basically, and three different types of scenarios under which you would be able to have electronic meetings. You remember at the beginning, it was you can have an electronic meeting for any reason, because the whole point of that was everybody was facing the same issue. And so there was a clear need to be able to have fully electronic meetings at the time. Then for last year, that was restricted a bit, and you could have electronic meetings if there was a state of emergency declared within your jurisdiction, if there was electronic attendance for qualifying medical conditions, and these were all, of course, related to COVID as well. But now we have a pretty limited situation from January 1st, 2022 onward. The legislature has kind of left us in a gray area because the pandemic did not stop, right? The need for electronic meetings did not stop. And previously, the Open Meetings Act actually was a little bit, there were some open questions about how friendly and how it was to electronic meetings and how possible that it was to attend electronic meetings. But now it's pretty expressed that the only way board members can attend meetings electronically is if it's due to an absence for military duty. And so it's pretty restrictive now as it relates to as it relates to electronic meeting attendance. But again, we're all in the midst of this issue. So military duty is not, not a very common thing, and certainly not the most common issue that everybody's facing right now. So as of now, the Open Meetings Act is you only accommodate for military duty. So because that is the expressly provided electronic attendance option, I think we should just remind ourselves about some of those requirements that are in the Open Meetings Act as it relates to electronic attendance. So you need to make sure that you have this two-way communication set up. Now, some of these things that I'm going to list in both here and when we talk about what's required in notices, some of those were more geared toward for public that's attending electronically rather than board members. But these are all still things to consider, and things that we'll want to make sure we address in our meetings. So you need to make sure you have the option for two-way communication, so that people can have that interaction. You can't just have a video feed set up, right, with no ability to communicate. Each member attending electronically must state that they are attending remotely and their physical location. However, there is an exception for that for military duty. There's a good reason why you don't necessarily have to have, or you don't have to have your location if it's for military duty. One important thing that I'm sure most of you have already addressed is adopting procedures for providing notice of the absent member, how to contact the absent member in advance. The Open Meetings Act requires townships to have procedures in place related to these accommodations. So that is something that if you don't have any OMA procedures, policies and procedures in relation to these absences, that's something that you'll want to talk to us or your legal counsel about, to make sure that you have everything that is required for that. Because I think some people thought, well, we're not doing any electronic meetings, so it doesn't matter. But the Open Meetings Act requires this accommodation in relation to military duties. So it's something that you will want to have policies and procedures on.
And so,
sorry, go ahead.
With this, on military duty, this is where we can see the nuts and bolts of why the township would be prohibited from providing this accommodation to other board members who are absent for some other purpose other than military duty leave. So it's because the OMA now provides that you provide these benefits to people away on military duty. It carries the implication that because the legislature didn't say you provide this benefit to other board members who might be absent, unaccommodated, that's where we get into the OMA no longer provides open electronic attendance for those for other reasons. So the medical condition exception that was allowed in 2020, as well as for a local state of emergency, that now in 2021, this is where we see that only those away on military can fully participate in an electronic meeting, and that full participation. So issues of voting or deliberating on matters, it comes because the legislature expressly provided this for those on military duty. It doesn't provide those for others who are absent for other reasons.
And then also just remember for posting notice, you always post notice on your website, I'm sure, but if you have a website, but also for electronic meetings, there's that requirement about having an agenda posted, and that agenda has to be posted at least 2 hours before the meeting, if you do have an agenda for the meeting. And you can once you post it, you're not required to keep updating it if any changes have been made to the agenda. But you just have to have that at least 2 hours before for an electronic meeting. There are those specific things that had to be in public notices for electronic meetings. So again, just make sure that, and these are listed in the Open Meetings Act, these would probably be listed in your policies and procedures as well. It's a good thing to have it's a good thing to have all of the requirements within your policies and procedures, obviously, so that all these specifically enumerated things are getting included. So, you know, why the meeting is electronic, either in part, if it's in part for one member, which member will be participating electronically, how the public can participate, and we'll get to this a little bit more in discussing potential avenues, future avenues for public participation, how the public might contact members of the public body attending electronically, and then also options for people with disabilities to participate. Now, let's see here. Skipped one, sorry. So in terms of, those are all the things that have kind of, you probably are mostly familiar with already, right? Who can participate and kind of what you have to do. Most of you have done these things already and you're well versed in this. But there are the ongoing questions now about what we do in 2022. As Jake mentioned, there's concern with, there's still a lot of concern with COVID and the Omicron variant, and having at least options for people to participate in the public, and also the reality that some board members might be in the position where they cannot attend an in-person meeting. So the legislature, as with many other things, hasn't done townships many favors in providing clear avenues for this. They've restricted it certainly with the military duty, but you all are, as usual, in the position of trying to, you know, just make things work on a day-to-day basis. And this is another one of those situations is, you know, we want to provide the most options for people to participate, you know, the general public certainly, but even board members. So, you know, we can talk a little bit about how we might be able to do some of that. So there's nothing in the Open Meetings Act and the amendments from last year that would prohibit having an option for members of the general public to attend and participate meetings electronically. Now, there no longer is an option to have just a fully electronic meeting like some of you were doing before. The board, the people, everybody, no physical location. But there still is an option for the general public to attend and participate electronically if, you know, that's not precluded by the Open Meetings Act. So, but this is less clear with board members, certainly as it relates to them participating as board members, but even the open question about, you know, whether they could attend or give comments, and we'll talk about that a little more. So one thing to consider when you're talking about just the general public, and your board says, we would really like to have some sort of electronic option for people to attend and participate, maybe fully participate in the meeting, give public comment and things like that. A couple of things under the Open Meetings Act to consider on this is you cannot exclude members from attending in person. So again, not only are we not able to have these fully electronic meetings, but, you know, you can't use an electronic attendance option as a way to exclude anybody from attending in person. I mean, you can only exclude people if there's some valid reason under the Open Meetings Act, like a breach of the peace. So this is within your discretion about what you want to do in terms of opening this up a little bit. And this would be probably within, you know, your procedures related to meetings and what you want to do. And these would also include these abatement procedures related to COVID. So what are your requirements going to be in your town hall as it relates to social distancing, mask use, and things like that. But it is worth noting that vaccination status can't be a reason to, you know, to exclude somebody, even if you are going to give an option to attend remotely. So in getting into the issue a little bit further about how this would look, the word hybrid is usually how we would talk about these types of meetings where you have in person, your board is in person, and then there is a audience in person as well. Having that electronic attendance option for other members of the public to participate, that would be what we would consider a hybrid meeting. So it's in person and electronic. So those are permissible for members of the general public if your township wants to do that. But I do think there are some considerations, and one of them is technology. I think technology is something that these are tricky to pull off. The fully electronic meetings, when it was the board and everybody in the audience, everybody was on Zoom, everybody's in this shared platform, right? So it's a little easier. You don't have the audio and visual problems. Everyone has their own camera, everybody has their own microphone, everyone has their own speaker. So it's all a pretty self-contained system. But when you start getting into trying to provide the ability for people to attend on Zoom, to hear the board, see the board, to hear the public comment going on, to basically get all the benefits that anyone in person would get from Zoom, that can be tricky to set up from a technology standpoint. So that's something that you will want to consider. And I was talking with Jake a little before this, and he was mentioning, and if you want to comment on that at all, about potential use of ARPA funds for some of this technology stuff, especially because it's related to COVID, and he has some insight on that.
And certainly, Steve, you know, what we know about permissible use of ARPA funds, just recently, last week, the Department of Treasury issued the final rule for how municipalities can use ARPA funds. We have not gotten the chance to analyze the issue yet, but with one of the acceptable categories of ARPA funds being measures to abate the risk from COVID-19, we certainly see how with township operations, you know, equipment necessary to host public meetings, you know, one of your most core functions of government, using those funds might be an option to kind of build this technology apparatus to be able to host hybrid meetings. And, you know, Steve, with hybrid meetings, you know, that's a term that gets thrown around a lot. And, you know, it's really kind of a range, a spectrum of how much input the public can actually have in a hybrid meeting. You know, if a community decided to present a recording of its township board meeting on, you know, a public access TV channel, that could certainly be regarded as a hybrid meeting of sorts. It's one that where there isn't, you know, two-way communication. The public can't provide public comment, but it's a way that, you know, access to the operations of government is provided to the public, and it allows folks to attend in ways. So while technology has certainly changed in a way that two-way communication through Zoom for public members of the general public participating in board meeting, you know, has evolved over time to allow more communication. How a township decides to adopt, if they want to do hybrid, there are certainly options available. And Steve, would you like to talk a little bit more about those options available?
Yeah, I think that's a great point and something to consider, that the degree to which you are going to give people the ability to participate, the general public, that could be controlled by what technology you have available to you, or also just a kind of a decision about what your board wants to offer in terms of being able to fully participate. It may be the case that the board only wants, like Jake was mentioning, basically a live feed, right, or a recording of the board meeting. So the ability for people an option for people to attend, but not necessarily to participate and have the option to give public comment. And the other range of that obviously is full participation. So the person, it's basically like they're in person, right? Everything is set up and they have the ability to fully participate. I think it's important to think that through and to be clear about that in your policies and your procedures and your notices as well. If you are going to tell everybody and put in a notice that they have the option to attend and participate in this meeting electronically, and then they can't, I think that would create some issues. So we'll just have to be careful about that and make sure that you have the technology in place to actually do what you say you will. And I think it's important to, in terms of notices, to be clear about this as well, to let people know what their options will be. And you can, let people know that you can be clear, maybe if you're going to just provide a video feed, for example, this can be viewed here, but this is an in-person meeting. The only option for participation is in person. So these will all vary depending on the context of what each of your boards decide to do. So I think it's something that you'll definitely want to discuss with your legal counsel, but then also with your IT people as well, and just trying to make sure that you have everything that you need to accomplish what you want in this regard. Now, the general public thing is a little more of a clear situation, right? There's nothing precluding you from creating these avenues for participation for the public. And, it's an admirable thing and wanting people to be able to do that. There's the same good intentions that could be there for these board members to be able to at least participate in some form. But it's much more complicated, and particularly, as we said earlier, the Open Meetings Act is clear now that you can only accommodate board members for military duty. And so what we would take accommodate to mean as you are accommodating that absence and allowing them to fully participate as a board member. So to have that two-way communication, to be able to join in the deliberations, to be able to vote, to be able to fulfill the functions of the office, right? So it's clear that that's what the legislature, that's all they wanted to provide. But in sort of real practical life, we all are going to have situations probably where we have board members who, cannot attend a in-person meeting for a variety of reasons, but particularly in relation to the pandemic. So what can we do about that? And it's kind of an open question right now, and it's going to be something that each board is going to want to consider carefully, especially with legal counsel, to make sure that the approach they take is something that will work. So as we said, we've already established if you have a military duty reason, that's fine, and you have to accommodate that. But if not, we can't fully accommodate. So even if it's this person has some COVID or medical reason, we cannot be getting to that level of full accommodation for this person. That's clear. But the next sort of level of questions then is where there is some gray area. Is there a way for that board member to still somehow participate, maybe to listen in, to even give public comment? That is something that there are different interpretations on. The Open Meetings Act does not make a distinction for public comment purposes between a board member and a member of the public. So there is an argument that a board member is also a member of the public. So there are a couple of ways that people might come down on this. One would be, if we are going to open up our meeting and have the infrastructure there for members of the public to participate and to give public comment, then while our absent board member cannot deliberate and vote, we should allow them to just attend like a normal member of the public. And if they want, as a member of the public, they can give public comment. That would be sort of one view of that. The other view, though, would be, because the Open Meetings Act is clear about the fact that members cannot be accommodated, that aside from for military duty, if you gave them that option to attend and to give public comment, to participate in that way, then you are creating that impermissible accommodation. You're allowing them maybe not to have a full role, but you are allowing them to, you know, through public comment kind of deliberate. And that's something that, you know, others see as being impermissible. There are also other issues related to that outside of the Open Meetings Act. So for example, if a board has created this public forum, right? They have the ability for the general public to attend and to give public comment, and you restrict this board member who wants to just do this as a member of the public. You know, are there potentially First Amendment issues with that? So this is something that there is not a clear answer on, and it's something that will have to be discussed by each board, depending on what level of electronic participation they're setting up for the general public, and then the sort of second level then of how, if at all, they would like to try to have some board member involvement. So this is something, again, that is really, it's going to be a unique situation for different boards and really context specific. So we would strongly recommend that you reach out to us or your legal counsel to make a plan on that before you move forward with that.
And the thing is, Steve, that you're absolutely right with saying it's extremely context specific. You know, if you have a township that doesn't allow any public electronic participation, then it seems to be a much more straightforward analysis, and they haven't created that forum, you know, and it's just something where the township doesn't allow electronic participation unless it's a case where a board member is away on military duty. Then in that situation, so if a township would avoid the question totally by not allowing a hybrid meeting.
Right, and I mean, that is something to consider in general as well. Like a lot of, you're under no obligation to provide any of these alternate avenues, though, you know, understanding that we've been put in this position by the legislature of not having these same options that we had before for fully electronic meetings. But it can, you know, in line with what Jake said, it can open up other issues, you know, as you start allowing and providing for more of those avenues.
So now we enter our next segment of the presentation, federal vaccine mandates, and will they apply to Michigan public sector employers? So, you know, there's a lot of language kind of being thrown around with federal vaccine mandates. So we want to be extremely clear what we're talking about when we talk about a federal vaccine mandate. That would be a order from the federal government. So currently there are three. There is the OSHA ETS for employers with 100 or more employees. There is a CMS vaccine mandate, which applies to some healthcare providers, which requires vaccination for their employees. And then there's also the federal contractor vaccine mandate, which is presently enjoined, which requires certain federal contractors and subcontractors to require their workforce gets vaccinated. But even within the federal vaccine mandates, there's further division. The OSHA ETS for employers with 100 or more employees, in and of itself, is not a vaccine mandate because it allows a testing alternative. So if an employer who is covered by the OSHA ETS didn't want to mandate their employees get vaccinated because they, think that that's their employee's option to make that decision, that would be allowed under the OSHA ETS, and the employer would simply have to adopt the testing alternative, whereby individuals who aren't vaccinated are required to submit to weekly testing. So a lot of litigation has surrounded these federal vaccine mandates since they've been announced. So the OSHA ETS was released on November 5th, was subsequently enjoined on a nationwide level, got evaluated by the Sixth Circuit Court of Appeals. And then on December 17th, 2021, the Sixth Circuit Court of Appeals upheld the OSHA ETS. And now it's under review by the US Supreme Court, and a decision still hasn't been rendered in that case. They heard oral argument on Friday. So, that this is definitely an area where it's a moving target. And so it's important to kind of be evaluating how these federal vaccine mandates may impact your township.
And Jake, I just wanted to say to everybody, in case nobody heard, or anybody did not hear, that we will take questions at the end of this. So the Q&A function on here, you can put questions in, and we will just take questions related to the 3 topics that we're talking about at the end of the presentation.
Oh, and we can go to the next slide, Steve. So as discussed, those are the 3 federal vaccine mandates, and their applicability to different types of employers. And Steve, we can go to the next slide. And so this was also touched upon about how they were, subject to different litigation. And so now here we are at the OSHA ETS. And so one thing that is extremely important to keep in mind about the OSHA ETS for employers with 100 or more employees is that due to procedural reasons, how it will apply to Michigan public sector employers is unique from the other 2 federal vaccine mandates. So under the federal OSHA regime, OSHA does not apply to states or subdivisions thereof. So local governments would not be impacted by OSHA. However, some states have voluntarily adopted a state plan under OSHA where the state can promulgate rules that match the OSHA standards, and the state enforces kind of the purviews of OSHA through their state agency. In Michigan, we are a state plan state, with the MyOSHA being the relevant regulatory agency. Under the MyOSHA Act, it has a requirement that MyOSHA requirements will apply to local governments. So MyOSHA explicitly calls it out in the plainest terms that MyOSHA standards apply to local governments. Also in the MyOSHA Act is this idea that Michigan has an obligation to adopt a state analog to a federal emergency standard. So this is kind of unique because it gives the state some discretion in what will be in its emergency standard. The Act states that the state analog to the federal emergency standard must be just as effective as the federal mandate, but it doesn't foreclose the option that it could be more onerous than the federal standard. So when OSHA released the ETS in November 5th, it got the ball rolling of Michigan having this obligation to adopt a state analog to the OSHA ETS. And with that, MyOSHA still has not issued their state analog, which would be applicable to certain local employers. We know that the MyOSHA state analog will be substantially similar to the OSHA ETS, but we don't know if MIOSHA will voluntarily pass a more onerous standard, as is the agency's right per the act. So this is something where we are watching to see this. We've been in contact with the agency, and they've reiterated that they have 30 days until the effective date of the OSHA ETS to release the state analog. And it was just January 10th that the OSHA ETS had its effective date. So we anticipate hearing more from MIOSHA with what will be the state analog more soon. But a big caveat to that is that the OSHA ETS is still under review from the Supreme Court. So there is the potential that the MIOSHA state analog won't be released if the Supreme Court rules that the underlying federal standard that it relies on, the OSHA ETS, is unconstitutional. So, unfortunately, this is a very wait and see area. But, in the present time, we know that the requirements of the MIOSHA state analog will be substantially similar to the OSHA ETS. And because it will be, a great place to kind of think about whether this could potentially apply to your township would be to look at the requirements of the OSHA ETS. So while MIOSHA may certainly deviate in who the standard applies to, so they might include smaller employers, as is their right to adopt more onerous regulation, how low MIOSHA would go still remains to be seen, or whether they will simply mirror the OSHA ETS and require that it only apply to employers with 100 or more employees. And this is something certainly that we've been following closely, and its potential impact to employees, and will continue to do so. So the next federal vaccine mandate is a CMS vaccine mandate. This is something that we would regard as having limited applicability to local governments. It's something that applies to facilities covered for Medicaid, Medicare certified providers and suppliers. The one narrow situation where this could apply to a municipality would be if the municipality had contracted to provide certain services for a covered entity. So if you have some arrangement with, a healthcare system, or possibly a community mental health center, rural health clinics, to name a few, that you have a formalized arrangement, the CMS vaccine mandate may apply to some of your employees. But in that instance, it would have to be something that would likely be clarified by the party that you were in contract with as to whether or not they think the CMS vaccine mandate applies to you, and by your association with them, the CMS vaccine mandate would apply to some of your employees. But that's a very rare that we believe it would be applicable to local governments. So the next is the federal contractor vaccine mandate. It's currently subject to an injunction that prevents it from going into effect. And so its status compared to the CMS vaccine mandate and OSHA, which are currently being evaluated by the Supreme Court, the federal contractor vaccine mandate is presently enjoined. That was an interesting vaccine mandate on how it would apply to different employers, because the way it operated was if an employer was going to be covered by it, it would be in a contract that they signed to provide services as a federal contractor or subcontractor. So, certain language would impose that. But once again, we think this is one that has limited applicability to local governments, especially while enjoined. So next, we turn to COVID-19 protocol mandates. So in late December, the CDC changed some of those guidelines. MIOSHA COVID-19 rules. And this is kind of going back to kind of our discussion of federal vaccine mandates and how you regulate your workforce. So MIOSHA COVID-19 rules. MIOSHA still has some rules in effect that impact healthcare providers and how they manage their workforce with COVID-19 health and safety issues. And so under the MIOSHA, and this is MIOSHA once again adopting a state analog to a federal ETS. So this actually is a state rule that was adopted pursuant to its obligation to have an analog to a federal rule. And so this applies in the healthcare context, and MIOSHA adopted rules that provide certain healthcare facilities with workers who respond to emergency calls, perform healthcare and services, or transport patients to medical facilities might be covered by these MIOSHA COVID-19 rules. And so it would specifically only apply to those employees who are providing health services, so like EMS, fire, law enforcement. And it applies in those work settings where care is rendered, not all township employees. So depending on its applicability, we would certainly be interested to see if, to discuss what that requires local government, what COVID-19 protection measures a local government is required to adopt to satisfy this MIOSHA COVID-19 rule. And so some of those requirements include requiring certain employees wear face masks, conducting daily health screenings of employees, requiring employees to isolate or quarantine on account of the employee being impacted by COVID-19, and adhering to requirements that the township provide covered employees paid leave to secure, recover vaccination and paid leave for isolation and quarantine purposes. So once again, this MIOSHA COVID-19 rule would only apply to a narrow subset of township employees, and it just requires certain safeguards be put in effect. So changes to CDC quarantine and isolation guidelines. So in late December 2019, we think you've probably heard of it. They changed, the CDC changed its guidelines on how long certain employees must quarantine and isolate when impacted by COVID-19. And so this is relevant in Michigan because of Michigan's COVID-19 Employment Rights Act. And so under the COVID-19 Employment Rights Act, Michigan states that one of the bases for an impacted employee to return to work is to have satisfied the requirements of quarantine and isolation as defined by the CDC. So in this way, as a Michigan employer, when your employees return to work, is in part a function of what the CDC defines as quarantine and isolation periods. And so what we saw in the updated CDC guidelines in late December was a reduction in quarantine and isolation periods. And so we can go to the next slide to kind of see how this operates. And so first, with the CDC guidance on how long individuals must isolate and quarantine, it's always important to check the definitions to make sure everyone's on the same page. One thing that was new with these new COVID-19 isolation quarantine guidelines is that the CDC altered its definition of fully vaccinated, and now it requires some situations where an individual must be boosted to be considered fully vaccinated. And so the first that we talk about is what to do if an employee has close contact with an individual with COVID-19. And as you can see, there are some, and when the employee can return. As you can see, under the Michigan COVID-19 Employee Rights Act, there is the option that the employee can return to work when they're advised to do so by a healthcare professional, as well as there are certain CDC requirements where we divide vaccinated employees' quarantine period from unvaccinated employees' quarantine period. So if an employee is considered fully vaccinated, they don't have to quarantine when they've had a close contact, but they must take additional safety measures such as wearing a well-fitting mask for 10 days. That's not the same for employees who aren't considered fully vaccinated. Employees who aren't fully vaccinated must isolate at home for 5 days. And then once upon returning to the office, if they don't display symptoms, they must wear that mask for that full 10-day period. Next slide. So then, of course, there is what happens if an employee tests positive for COVID-19. So with this new CDC standard, the isolation period was reduced. Now an employee under current CDC guidance only has to isolate when testing positive for COVID-19 for 5 days at home to stay out of the workplace. Then once, notably, the CDC isolation guidance does not require as a precondition that the employee test negative for COVID-19 when they return to work after 5 days. It only requires that there be some symptom improvement for the employee to return to work after 5 days. And so, if that employee who tests positive is looking to return to work, then they have to continue to wear a mask for an additional 5 days upon returning to the office. Once again, we have another category, employees who display symptoms but have not yet tested positive. So this goes into kind of the requirements of the Michigan COVID-19 Employment Rights Act. And so if an employee displays symptoms, they must refrain from entering the workplace. They can return to the workplace when all the following apply. So the employee has improvement of their symptoms, 24 hours have passed since the employee's last fever without the use of fever-reducing medications, and the CDC's isolation. So that's if the employee tests positive for COVID-19. But if the employee simply displays symptoms but then tests negative, the employee wouldn't be obligated to stay out of the workplace. And so we are glad everyone attended, and now we can move on to the question segment. A great place to ask those questions is the Q&A function at the bottom of your screen. And it looks like we have some questions, Steve.
Yep, we have a few questions here. So the first question is it possible to conduct your meeting electronically via one-way communication so that the public is excluded from things such as public comment? I think what that question is getting at is whether you can just have the public view the meeting. Is that how you understand that question, Jake?
Yeah, And,
Yeah.
with that, Steve, that sounds like that's just something where the township board has made the decision to kind of live broadcast their open meeting. So they might, use a YouTube channel to kind of show the film. So yeah, that would be permissible as a hybrid meeting. You can have it where it only allows members of the general public to observe the meeting. It wouldn't be much different from, our existing understanding of other hybrid meetings, like if a township elected to put its meeting on a local access cable TV channel.
Yep, I agree with that. Yeah, so just, the general idea with that is you're under no obligation to provide any of that right now, in terms of additional accommodations or anything. So anything extra you want to do for the general public, if you only want to go as far as providing that feed just so they can view it, you're essentially providing that as a, as a courtesy to them. So, so that would be fine. The next question is, do you see any reason why a township cannot continue to have other professionals fully participate, such as planners and the attorney? I don't see any issues with that, because we have to remember participation means one thing for board members, and OMA is talking about board members when it relates to electronic participation. And I would probably put anybody that's contributing at the meeting and more of a public comment category, right? So if you have your professional services or anything like that, those are not, those individuals don't have deliberation or voting function. They're not a board member, so I do not see any problem with them participating. And then, do you have anything to add to that, Jake?
I do not, Steve.
And then the final question that we have, and again, if anybody else has any, you can just use the Q&A box. Is there a bill that representatives or senators are introducing to address expanding the remote participation to include medical? From everything I have heard, there is not a lot of appetite in the legislature to touch the Open Meetings Act again. It was a very contentious debate. It's always been a contentious issue, the idea of electronic participation, and for a long time there were always bills introduced to fully prohibit having electronic participation. And so last year and the last couple of years, there was the acknowledgement that it needed to happen for COVID, but it was very narrow on purpose, and now it's even more narrow going forward. So it does not sound like, from everything I've heard from people I know working in the legislature, in and around the legislature, that the legislature has any intent on expanding that. And it looks like those are all the questions we have. If anything else comes up, though, you have our contact information here. You can either email Jake or myself, and we'd be happy to, share anything with you or follow up on something. So please feel free to contact us.
And absolutely, with those questions, we know we didn't get to address all ways that COVID-19 will likely impact your township in 2022. But if you have any questions that weren't addressed by this presentation or dealing with a unique situation, please don't hesitate to reach out. Everyone at the firm would be glad to assist you on these matters. We know how, some aspects of COVID-19 touch highly regulated areas, and we would be glad to assist making sure your community is able to get these questions correct.
We actually got one more question, Jake, if you want to take this one. Can the township require elected officials to wear masks?
That's a great question. So the first, we would have to kind of get into the scenario of when is the township and where, when and where is a township requiring the elected official to wear a mask? So when we look at when people have the right to access township facilities, township, any township board members, as well as members of the general public, have an absolute right to access township facilities in two scenarios: to attend a public meeting held pursuant to the Open Meetings Act, and then second, to vote in an election. So as a broad rule, if you had a elected official showing up to township facilities and not wearing a mask in violation of a policy that the community had adopted, that policy could be enforced in scenarios that don't touch open meetings or voting in an election. But if it's a situation where the township board member is showing up to the open meeting and refusing to wear a mask at the open meeting, remember, you can only remove an individual from a public meeting held subject to the Open Meetings Act when there is a breach of the peace actually committed. So for that, does a township board member breach of peace by not wearing a mask? There are a lot of situations where folks do not wear a mask. Grocery shopping and such, you see folks not wearing a mask. That a community would be extremely hard pressed to say that that there was a breach of the peace committed by someone simply not wearing a mask at a public meeting. But there are other scenarios. So we certainly see where township could adopt policies requiring face mask wearing within the township facilities, so long as there were necessary carve-outs to protect individuals' right to attend public meetings and individuals' right to access township facilities to vote in an election. What are your thoughts on that, Steve?
I would generally agree with that. I think it's a really good point about the fact that there are particular concerns when it's related to those two functions. So the question does not specify when the mask mandate or requirement would be applied, but if we infer that it would be related to a meeting, I think Jake is right. We'd have to be very careful about that, and it's probably not something that would pass muster in relation to that breach of peace standard.
And with that is a very context-specific decision that we would encourage you to seek the advice of the township's legal counsel before adopting such a policy or seeking to enforce it. Options might be available with this mask that we would want to discuss the context before someone were to adopt that policy.
And that is the last question now that we have. All right, well, thank you again to everybody for attending. We really appreciate it. And again, please feel free to contact us if you have any follow-up questions on these, or if you have these issues that certainly will be arising, in townships throughout the state.
Thank you, everybody. Hey, Steve.